Hello, family. This is Natasha Robinson. I am a professor and I am the creator and curator of Legalese Please. This is a platform that is designed to decode, demystify, and deconstruct legal language. In short, we build you up by breaking it down. It being the comprehension of any terms, policies, procedures having to do with the law and having to do with you. Welcome to another episode of Law in Real Life and Law in Real Language. And so I am going to talk to you about one particular question that I hear all the time. And that question is, why is it that if someone has evidence against them, why are we even having a trial? Why is this a no-brainer? Why are we waiting to convict this person or to acquit and free this person? And so I want to talk to you about two things. One, I want to talk to you about rules of evidence. And then secondly, I want to talk to you about the different types of evidence. First off, rules of evidence are those type of evidence that lets persons know in the court system that you cannot just have evidence without there being rules that are met. So some of those rules are foundation, which is the evidence what it's supposed to claim to be? So did you get this evidence off the street, or has this evidence been kept in a way that no one can mess with it? No one can try and infiltrate it or change it or anything like that. Secondly, is this evidence relevant to the ultimate question of whether or not a suspect actually did what they are accused of doing? And so there are three types of evidence. Three types of evidence. First is physical. Remember physical. Physical is any type of evidence that you can touch, any type of evidence that you can see. And so that evidence has to meet the rules of evidence. Otherwise, it will not be considered as to whether or not a suspect is guilty or innocent. The second type of evidence is called testimonial evidence. That's a type of evidence that we can hear or we can read. We can hear it because they're testifying in court under oath, or we can read it because you have notes of everything that everybody is saying, called a transcript. The third type of evidence is demonstrative evidence. That is the evidence that can assist us in understanding whether or not the suspect is actually guilty or innocent in a court of law. The last thing that I want you to know is that there is a difference between factual guilt and legal guilt. Factual guilt is I saw the person do it. I heard what they said. There are admissions of guilt. There are witnesses. There are photos. There are videos. You name it. But legal guilt is a little bit differently because the freedom of a person is so important. There must be things in place to make sure that the evidence that is collected in real life is the evidence that can be relied upon in court. So if you have filmed someone engaging in maybe a criminal act, but you violate their constitutional rights, then that evidence cannot be considered because that is a rule. If you have evidence that says that a person has done something, but that person is not this person who is facing the charges, then by law, that person needs to be set free and acquitted. So these are just some behind the scenes terms, understandings, and explanations about how law in real life is impactful and is impactful to you. Tune in next time for another quick episode so that we can learn together in community. Have a wonderful day.